Hi, my name is Matthew Townsend. I'm a barrister. I've been practicing in planning and property law at Victorian Bar for about 25 years. The purpose of today is to provide an overview of restrictive covenants in Victoria, both in theory and practice, although the intention is to focus on the practical rather than the theoretical. The overview is really directed towards property owners, thinking about modifying restrictive covenants that apply to their property in anticipation of seeking planning approval for development of land. But it's also, I think, or hopefully of use to solicitors who are perhaps about to run an application through the Supreme Court for the modification of a restrictive covenant for the first time, and also obviously other junior barristers that are interested in running one of these applications. The notes that I'm going to run you through really are based on a set of lecture notes that I prepared for the property law course at Melbourne University a few years ago, but I've constantly been updating them since they were first drafted. So they are current as at the end of 2022, although the examples may change. In truth, this is a relatively stable area of the law, and very little seems to change from one year to another. The practice does a little in a way, or in small degrees, but ultimately the relevant provision of the Property Law Act that I'll take you to really hasn't changed for over 100 years. As I say, one of the things that I want you to be able to do is to know that these notes exist. What are they? They go for about 90 pages. And really what I want you to do is to be able to know what's in them so that if you do have a problem, you think, oh, I remember saying something about that in those notes. So you'll see at the beginning, there's a fair bit of theoretical material. What I really want to focus on is this section here, Section 84(1)(c) of the Property Law Act. So I'll try and get there as quickly as possible. So there's a section at the commencement of the notes about the theory or the theoretical components of restrictive covenants set out by Justice Gillard and Fitt and another in Luxury Developments in 2000. But really what you need to know is that restrictive covenants were a crude form of planning control. And so in the absence of planning schemes that you find in contemporary land development today, what you had was a series of contracts between landowners, particularly in the creation of a subdivision. And the network of restrictive covenants was really an interlinking network of contracts between sellers of land and purchasers of land. But the weakness in that schema or that regime is that you could really only make a contract between parties who hold the land at any particular moment in time. So you can't make a contract with somebody who's already sold their land. What that means as a matter of practice is that when you come to analyse who has the benefit of a restrictive covenant as distinct from who has the burden, so the burden is you, the landowner wishing to develop your land, those parties with the benefit of the restrictive covenant, those people with the parcels of land highlighted yellow on that map in front of us, it's really a matter of chance as to whether your neighbour to the immediate north has got the benefit of the restrictive covenant, or whether the closest person with the benefit is some 250 metres away. And we've found everything in that. Some landowners are unlucky. That is, that they were the first parcel of land to be taken out of the subdivision, in which case they've made a promise with everyone. So everyone in the subdivision can enforce the covenant against them. Conversely, you can find that you're the last party that takes the land out of the subdivision. So therefore, you've promised nobody. Maybe the people who still own the roads, they've long gone, part of a deceased estate. So for all intents and purposes, there's no one who would force a covenant against you. That's the gold standard, because that really means that you can go to the Supreme Court and say, listen, we were the last lot taken out of the subdivision. There's really nobody who's got the benefit of the restrictive covenant. Can we please remove it? And the court is quite often happy to do that. So the most common covenant that we deal with are single dwelling covenants, but they can take a variety of forms. A lot of people come to us wanting to modify a restrictive covenant for building materials, so they might have an obligation to build out of brick or stone, or a roof out of tiles, and they want to use a Luca bond or something like that. But mostly it's about the number of dwellings that you can have on the land. Some covenants control height, so you can have any number of restrictions on a building envelope, and sometimes someone wants to intrude above the building envelope in order to achieve a particular built form outcome. And that's the kind of thing that we can help with people as well. There's a number of technical requirements. If you're a solicitor and you're wanting to stress test a restrictive covenant to see whether it's enforceable or not, the matter that you really need to focus on is this last component. The benefited land must be easily ascertainable, because that's where a lot of covenants fall over when they're pressed. Touching and concern the land, annex to land, easily ascertainable. So there's a number of cases here: Beeman and Burren-Darroch City Council, more recently Re Hunt, and also Re Ferraro, cases in which the Supreme Court has not been satisfied that the land with the benefit of the covenant is easily ascertainable. And in other words, the Supreme Court wants to be able to say with some degree of certainty who can enforce this covenant. And if there's a degree of guesswork involved, then it's not likely that the Supreme Court will be happy with that, and will find that it's unenforceable as a matter of law. So again, what I've said in this next section is to explain the history of restrictive covenants and the way in which they intended to create a crude form of planning control. And here you have a lovely subdivisional advert from the Ranelagh Estate in Mount Eliza, which designed and laid out by Mr. Walter Burley Griffin. And this really is the forerunner to the contemporary planning schemes that we see in Victoria today. There's another example there that was the subject of Conlon and Benton, a modification application in the Supreme Court. You can see the lots over on Woodland Street, which are intended to be commercial premises, and then you've got single dwelling lots throughout the balance of the estate. Sitting in Stonington and Wallish was another restrictive covenant case in Stonington, very close to the Chadstone Shopping Centre. And the purpose of that case, or the objective of that case, was to modify the restrictive covenants in order to allow for a sporting facility, which was ultimately successful. And you can see there the Malvern Garden Estate, and the objective there of the excavation controls on the restrictive covenant was to avoid land being sold off to land speculators and then being stripped of its contents. For instance, clay or for soil for construction elsewhere, leaving a gaping hole in the middle of the subdivision, which makes sense. It is not a control, or it was found not to be a control, on the excavation of soil for the purposes of constructing buildings. Riazardi and others, that's a case in which we had to go to the Supreme Court to seek a variation for the top layer of that, or the first story of that building that had been built in contravention of the brick and stone obligation, and the Supreme Court was happy to modify that to allow us to build out of lightweight building materials. Planning schemes are now the primary means of controlling land use in Victoria, but that's not to say that restrictive covenants are not still being created. They are still being created, and we see those. We see restrictive covenants quite often run into 1 or 2 pages, listing the variety of different controls that people have to adhere to in the construction of their land. Might not only numbers of dwellings, but location on the lot, size of the building, fence height, you name it. They can be quite extensive. Prior to 2000, you could have a planning permit that would breach a restrictive covenant. But in 2000, a case that went to the Supreme Court by way of injunction, there was an application to enforce a restrictive covenant in Ivanhoe. And there was such a hullabaloo over the outcome of that case. Although the landowners were successful, the Victorian Parliament resolved that it was unreasonable for people to have to take that step, and that ultimately people should not, or the developer in that case, luxury development, should not have got a planning permit to allow it to breach the restrictive covenant. So from 2000, if you get you can't get a planning permit that facilitates the breach of a restrictive covenant in Victoria. And so that's why most landowners will go to the Supreme Court or will go through a planning permit application for the modification of a restrictive covenant before they get to the planning stage of the development process. That's a contemporary photograph, aerial photograph from the Fit and Luxury development case. You can see that there's still only one sad-looking dwelling on a property that was subdivided for 3 dwellings. Unfortunately, those 2 properties or those 2 lots are probably never going to be developed on. So I've already said that since 2000, planning permits can't result in the breach of a restrictive covenant, which has really created a lot of the work in the contemporary work of the Supreme Court for the modification of restrictive covenants. Interestingly, planning permits cannot be conditioned on the later removal of a restrictive covenant. However, you can have a permit that allows you to modify a development application in order to comply with the covenant. So in other words, if you put a development application in for lightweight construction materials and the covenant says that the building must be built out of brick and stone, then you can have a note on the plans that say walls must be brick or stone, and the tribunal will be happy to sign that off. Restrictive covenants are common in Victoria. Some areas of Melbourne, you'll find that they're extraordinarily popular. Reservoir is probably one of the largest one of the largest networks of restrictive covenant. You find them all the way out to Wantona, down to Brighton, through Paran, and all through Melbourne's east. Interestingly, they can be sufficiently intact that they actually form their own neighbourhood character areas in a place like Baldwin or Baldwin North. And if you take a drive around some of these areas, you will see that the network of restrictive covenants is so intact that you just will struggle to find any form of unit development or even dual occupancies on a lot. And it makes for quite an interesting neighbourhood character. And if someone came to me and said, look, can I help you modify a restrictive covenant in this particular area? I'd probably say, listen, it's not really worth it. Go and find somewhere else. But that's not true of all areas in Baldwin North. We're often asked to modify covenants in that area. It just depends where you are. As I mentioned before, restrictive covenants are still being created. How do you go about it? How do you identify the burdened land? Well, typically that is your land. And you can find that on your register search statement. It'll have a line item that says encumbrances, and then it'll refer to a particular covenant. Then when you get the covenant, that's when you need to start doing your analysis. They're quite often referenced on the imaged certificates of title as well. You can see an example there. Identifying the benefited land, this is more difficult. And even though there are search firms that specialize in doing a beneficiary analysis, we often find they're wrong. And so by all means, go to a search firm, but please get it checked by someone that knows what they're doing. Because as I say, what the covenant actually says is not actually what it means as a matter of law, because we've found, again, for this concept of privity of contract, which I touched on a moment ago, that you can really, with some exceptions, only make a contract with somebody who's holding the land at that relevant moment in time, means that what you see in terms of, or what you read in terms of the beneficiary obligation or the attempt to confer the benefit, quite often it's not effective. And you've got to understand the rules as to when it's effective and when it's not effective to provide advice. And for those solicitors that are watching this, you just got to be careful, because if a matter goes through the Supreme Court and you've told the Supreme Court that you think that the beneficiaries are A, B, C, D, E, And then it later turns out that actually there's other beneficiaries that you didn't notify the court of, and people start to unwind the development approval and all the rest of it, then there's some real issues of liability there. So you just got to be really careful. Building schemes, an exception to this concept of privity of contract. So building scheme, you quite often find them described on grandparent titles, parent titles, and the like. And you can actually see one. I think I've got an example down here. Yes, here you go. If you see the red writing, that was, what date was that? 1939, looks like. It was an attempt to get around this privity problem by essentially saying a building scheme means that we all agree from the outset that we're going to have an interlinking network of obligations and rights. And that, in some cases, is sufficient to get around the issue of privity of contract that I've referred to, but it's often ineffective. And so more often than not, when we see reference to a building scheme on a certificate of title, we're always skeptical as to whether it's effective or not. And there's a number of cases that help you work out whether that is effective or not. One recent example was Randall and Newell, in which Associate Justice Derham says for a purchaser to purchase a piece of land, unless it's obvious on its face that there's a building scheme in place, then you shouldn't be bound by it as a purchaser of land, because it's not up to you or it shouldn't be an obligation on you as a purchaser of land under the Torrens system of title by registration for you to have to make further inquiries. You should be able to see on its face whether you are bound by a building scheme or not, which again reduces the number of times in which you can find that a building scheme is effective. Okay, so how do we go about modifying a restrictive covenant? One way you can do it is through modifying a restrictive covenant through planning permit. Now, I'm not going to spend a lot of time doing this. It's, in one sense, it's not something that I'm often involved in, because you don't need to speak to me. You can just do it yourself. And a lot of people try to modify restrictive covenants through the planning scheme, through a planning permit process. We often find, though, people will go off and do it themselves through the planning permit process. They'll lose 12 months. It'll cost them a lot of money in advertising. And because it's such a restrictive test, they ultimately come back to us saying, okay, well, we tried that, didn't work. Now let's go through the Supreme Court. And we quite often say, well, we did tell you to do that first of all, but sometimes people get through the planning permit process. And maybe it happens more than I know, because people just don't tell me about it. But it does seem to be pretty regular that people will go through the planning permit process, find that it doesn't work, and then come back to me 6 or 12 months later. Now, what you need to know about the permit application process, this issue of notice, okay? You have to notify all beneficiaries. That's what the Act says. So there's no discretion involved. You have to notify all beneficiaries. And so you have to go through that process that we discussed a moment ago in relation to who has the benefit of the covenant. Now, in a place like Camberwell, I've seen areas in which there's been hundreds of beneficiaries. In fact, there's some areas of Point Cook, Altona, some areas out there where there's hundreds. And I know of one case in which someone paid, I think, something like $10,000 for notifying beneficiaries. And then they got a couple of objections. And so, as I'm about to explain to you, that was enough for the whole process to get thrown out. They came to us and we went through the Supreme Court, and we were successful in modifying the covenant. Now, I really caution you about going through the planning permit process. Really, not only for the expense of notice, because that's not always prohibitive. Sometimes you can find that there's not much notice to be given because there aren't that many beneficiaries. What you need to be aware of, a couple of things. There's two provisions, Section 60, subsection 5, and for more recent covenants, Section 60, subsection 2 of the Planning and Environment Act. These are gatekeepers to the Planning and Environment Act process, intentionally introduced by the Parliament, the Victorian Parliament, to restrict the access to the modification process through the planning permit or through the Planning and Environment Act process. So I'll just say that again. These are gatekeepers intended to prevent people from using Planning and Environment Act process to modify restrictive covenants. In fact, the second reading speech for the introduction of section 60, subsection 5 was to the effect that the Planning and Environment Act process is only intended to give you the ability to get rid of deadwood covenants. Now, there aren't that many covenants that can be fairly described as deadwood. You may think that they're deadwood, but believe me, your neighbour might not. And the tribunal is likely to side with your neighbour over an argument as to whether it's deadwood. The mere fact that you are contesting it probably indicates that it's not a deadwood covenant. So let's come back to that in a moment. One of the other things about going through the Planning and Environment Act process is that if you can often find that you're opposed to the responsible authority, the council, and the councils are quite often represented by smart planners, smart solicitors, people who want to put a pretty forthright contrary position to the one that you're taking. So you can never think that you're going to get through this without someone really applying the blowtorch to you. And in contrast to the Supreme Court process, where the council is typically not involved, and where you don't have a contradictor in the form of the responsible authority or a council officer or council solicitor, the involvement of the council staff or the council solicitors can often make the difference between whether you get a clear run through the process or whether you get tripped up. So again, that's something for you to bear in mind. The Supreme Court sees the process as really being about the enforcement of private rights, whereas the council process, the Planning and Environment Act process, is really about public rights and responsibilities, your obligation to the public, notwithstanding the fact that you've entered into a private arrangement with beneficiaries, the other beneficiaries, it's still got a public element to it, which the tribunal will enforce. Whereas if you go through the Supreme Court process and you can convince the court that nobody really cares about this, not sufficient for them to come forward and actually express any opposition, then the court is generally pretty happy. There are some exceptions to that, but generally the court will be happy as long as you can demonstrate that nobody has got real opposition to what you're trying to do. Now, here's a third element of why the Planning and Environment Act process is difficult. Remember, the first one that I said was the issue of notice. You've got to notify everyone. The second one was the involvement of officers, solicitors for the responsible authority, the council. And then this third one is the section 60, subsection 5, or section 60, subsection 2. These are the gatekeeper provisions. Now, what does this say? The responsible authority must not grant a permit which allows the removal of variation or restriction referred to in subsection 4, unless it is satisfied that the owner of land benefited by the restriction will be unlikely to suffer any detriment of any kind, including any perceived detriment. So just have a think about that. You can get your application refused by the council or in VCAT on review because someone has a perception that they're going to be impacted by it. Okay, that is not a difficult test to satisfy. Okay, so that's section 60, subsection 5, and that applies for covenants older than this triggers. Come back. Section 60, subsection 2, on the other hand, there we go, for covenants created after the 25th of June, 1991, responsible authority must not grant a permit which allows the removal or variation of a restriction unless it is satisfied that the owner of any land benefited by a restriction will be unlikely to suffer financial loss, loss of amenity, loss arising from the change to the character of the neighbourhood, or any other material detriment. Okay, so we got rid of the perception of detriment, but ultimately this is still pretty restrictive. Now, if you've got a case that concerns this, I would suggest you read Waterfront, which was the decision of Michael Wright. A very well-researched, well-written decision in relation to the operation of Section 60, subsection 2. But suffice to say, you may find that you don't have any opposition under Section 60 or Section 60, subsection 5 or Section 60, subsection 2, and the tribunal still says, I'm not convinced that you've met Section 60, subsection 2. So in other words, the tribunal will arrive at its own conclusion in relation to loss of amenity, loss of change to the character of the neighbourhood, or any other material detriment, notwithstanding the fact that there's nobody there complaining about it. Okay? Now, hopefully you can see, well, I'm not a big fan of people going through the Planning Environment Act process. But, and this is a big but, Section 47(2) of the Planning Environment Act is a section that allows you to get a planning permit without notice to beneficiaries if you've been in breach for more than 2 years and that your works are lawful but for the presence of the restrictive covenant. Now, I'm going to explain this slowly and again because it is such an important provision. And in fact, one of the first questions that you should ask as a solicitor, and it's certainly one of the first questions that I ask as a barrister, if someone says to me, I want to modify the restrictive covenant on my land, the first thing is I turn to my aerial photograph and I have a look at it, but I also say, are you in breach at the moment? Because what Section 47(2) of the Planning and Environment Act allows you to do is to avoid all this problem of notice if you can demonstrate that you've been in breach for more than 2 years. So let's read the provision. Section 52, which is about notice, and Section 55, which is about referral, do not apply to an application for a permit to remove a restriction over land if the land has been used or developed for more than 2 years before the date of the application. So there's a few cases here that explain what that is intended to mean, and you're more than welcome to have a look at it. But it really comes down to this. These are real world examples that I had. Someone came to me say, I want to get rid of a single dwelling covenant on this land outlined in orange. My question: how many dwellings are there on there at the moment? Oh, there's 4. Beauty. Let's use 47(2) of the Planning Environment Act. We were successful. We got rid of that component of the covenant. Someone else comes to me and says, I want to get rid of the slate and tiles provision on my roofing material. I say, okay, well, what's your roof made out of at the moment? Well, it's mostly slate, but a little bit of perspex at the back. Beauty. We get a photograph, we take it to the council, and the council says, yeah, okay, well, you've been in breach for more than 2 years. You can have that element modified by way of planning permit condition. Perfect. So there's another example. Here's another one. Somebody wanted to build a beautiful Zincalume building at the back of their heritage property. We went to, did a site inspection, had a wander around, saw that part of the building was not built out of brick or stone. Same thing again, go to the council, say, listen, we've been in breach for more than 2 years. Please give us a permit under Section 47(2) of the Planning Environment Act. Council says, sure, no worries. Here you go. Here's your modification. And this is what it might look like. Here's your planning permit. The permit allows the variation to a covenant. The following conditions apply. Expiry of the permit. Okay, that's all you need. What do you rely on to demonstrate more than 2 years? Google Earth, Nearmap, MetroMap, historic imagery. There's a number of public links there and some private links. All means of demonstrating that you've been in breach for more than 2 years. Although if you've lived there, chances are you'll have photographs yourself. Okay, so that's really the introductory part to what I want to say to you, and we're halfway through this. I've really got half an hour to talk to you about. What I really want to talk to you about is the modification of restrictive covenants through the Supreme Court process. Now, when I say the Supreme Court process, what I'm really referring to is Section 84 of the Property Law Act, and in particular, Section 84(1)(c) of the Property Law Act, and that is that the proposed discharge or modification will not substantially injure the persons entitled to the benefit of the restriction. Okay, there are some provisions in relation to Section 84(1)(a) that deals with obsolescence, or Section 84(1)(b), which talks really about the fact that some people have agreed to a covenant being modified. Sure, they may be of interest in any application, but if you can imagine a Venn diagram, here's your substantial injury ground, and Section 84(1)(a) and Section 84(1)(b) typically will form part of your 84(1)(c) area. In other words, they don't really, 84(1)(a) and 84(1)(b) don't really add anything. 84(1)(c) is generally the provision that you can rely on in order to advance your case to the court, that none of the beneficiaries are going to experience substantial injury from your application to modify the restrictive covenant. Okay, so again, it's this provision here that the proposed discharge or modification will not substantially injure the persons entitled to the benefit of the restriction. That is the basis upon which you get your covenant modified. Now, there's still a discretion to the court to reject your application for discretionary reasons, notwithstanding the fact that you have established that there's going to be no substantial injury. But I can't think of any instances. I mean, there's a couple of reported decisions from a long time ago, but I can't think of any recent instances in which that discretion has been exercised against an applicant. Basically, if you can demonstrate an absence of substantial injury, the courts will say, sure, let's look at what you want to do. There's a discussion here about the sections of 84 of the Property Law Act, which I won't go into. Suffice to say that it's been around for a long time, over 100 years. 84(1)(b). Now, I'm on 84(1)(c), aren't I? Yes, I am. I've gone flying past it. Sorry about that. Here we go. Section 84(1)(c) I have described as the engine room of the Supreme Court's restrictive covenant modification jurisdiction. Now, there's a number of criteria that's helpfully set out there by Associate Justice Derham and Randall and Ewell. But really what you need to be able to, really the test comes down to this. Think about what the covenant can do at the moment without modification. Think about what you can do after modification, and then compare the two. And if the difference between the two is not going to occasion substantial injury, then you've established your ground under Section 84(1)(c). Now, how does that work in actual practice? The best example I can give is this case of Randall and Ewell. What we did in that case is that we sought to create a new dwelling entitlement on a parcel of land in Templestowe. And the test was not a comparison between what's on the land there at the moment and what will be on the land after the modification, because the land had never been developed. Very close to the Yarra, it was covered in trees, beautiful tall eucalypts. And it was important for us to demonstrate to the court that it's not a question as to what it's going to look like with a house on it, because we can get a house at the moment. what we need you to look at is what it's going to look like with two houses and compare it to what we're entitled to do, which is one house. And the court accepted that argument. So how does this work in practice? Really, what it means in practice is that you do have to spend some time contemplating what you could already do. So you might only have a single dwelling on there at the moment, but in truth, you could build you might only have a very small dwelling on the house at the moment, but in truth, particularly in some parts of town, you might have an enormous house. And so what is the impact from built form perspective from one enormous single dwelling that covers up 65% of the site area compared to dual occupancy that only covers 60% of the site area? How does that comparison stack up? And the court has accepted that sometimes what's proposed by a developer may have less impact than what you can already do under the covenant, which you can imagine under this test really demonstrates that you're pretty close to being able to demonstrate an absence of substantial injury. Now, I won't spend too much time on the detail of this. Maybe there's a couple of matters to be mentioned in passing. Matters such as building height, bulk, siting, vegetation, and windows and setbacks are not relevant. That's been said by the court. I think you've got to be really careful making that argument, because really a single dwelling implies an absence of the sort of impacts that we're talking about, which is building height, not so much building height, certainly vegetation, siting on the land, setbacks. They are consequences of low density. But anyway, the court said that, so far be it for me to say it's wrong. Traffic and parking concerns rarely amount to substantial injury. That's true, but nonetheless, traffic and parking can be a consequence of varying a restrictive covenant that controls density. So, for instance, if you've got a single dwelling covenant, you want to put on 4 dwellings, then you can't be dismissive, I don't think, about the impacts of traffic and parking, because it is potentially an injury. Court has acknowledged that corner sites are more likely to support variation. Impact on property values is of questionable relevance. True. The process of applying to the court pursuant to Section 84 of the Property Law Act. Now, your starting point, whether you're a solicitor, particularly if you're a solicitor watching this, is to download the guidelines for practitioners. And I'm pretty sure that this is a live reference to the Supreme Court website. So have a look at that. You need to demonstrate to the court what you intend to do, and so you need to have an affidavit as part of your application that explains what your plans are. Now, we used successfully this plan, indicative plan, in order to modify this restrictive covenant in a shopping strip in Coburg. Now, that's probably as crude as you're likely to get away with, and we were able to get away with it because there were no beneficiaries that objected to it, and ultimately it wasn't particularly controversial. On the other hand, you can see these plans here. These are the plans from the Randall and Newell case in Templestowe that I spoke about a moment ago. We knew that we'd have to go through the planning process as well, and sure enough, we had to have a fight down at the tribunal about planning commission as well. But we had some very detailed plans proposed for that case. And in truth, they were probably too detailed, because at one point the judge said, listen, a lot of what you're talking about, that's matter for the planning jurisdiction. I'm really only talking about a level of abstraction here, and I don't need to know where the windows are on the building. You can work that out when you go to VCAT. This is a modification that we got through agreement in Malvern, and we had this conceptual plan And that was enough for us to be able to agree that a building had to have 9 metre setback from Glenferrie Road, 5 metre setback from Haverbrack Avenue, 3 metre setback from the property to the south, and a single story setback from the property to the east. Now that was okay because we settled that case, but it wouldn't have been okay had we had to run a contested hearing, I don't think. And an example of plans that were deemed satisfactory were these plans, which are frankly just, I think, what's the expression? Volume builders designs. The court was happy with us showing what we wanted to do. I think the client wanted actually to use some of these builders, volume builders, for the development. So the court was happy that that was an expression of the developer's intentions. But this one was not deemed sufficient in a contested case. And it was a heavily contested case in relation to St George's Road and Toorak, Geshin Property Management and Yang, and the court was critical of plans that went forward on that basis. And really, the way in which we do it is that we start off with a relatively crude set of plans, although I've given this example of what I really would like to use in pretty much every case to begin with: some floor plans, first floor plans, and a three-dimensional rendering to help explain to the court what it's going to look like. Then as you get further and further into the litigation process, if it turns out that you end up having a fight with someone, then you've just got to put more detail in. You've got to review the plans. You've got to tender more detailed plans, really to identify with some degree of precision what exactly the amenity impacts are, and for the purpose, obviously, of demonstrating there's no substantial injury. That's right. Now, the other thing that you should know is that what happens is that when you make your application may be as simple as saying, cross out the word one dwelling and write in 3 dwellings or 4 dwellings or 5 dwellings or maybe 2. But if you're involved in a contest and it turns out that you're getting further and further towards either a litigated settlement or a negotiated settlement, chances are you'll end up drafting or negotiating something a little more detailed. And so it used to be the case, or we did it for a while, where we'd go to the court and we'd say, but it will not be a breach of a restrictive covenant to approve plans in accordance with the plans provided by ABC Architects dated whatever, numbered 1, 2, 3. We got pushback though from the titles office. We said, listen, stop sending us plans. We don't want them on the register of titles. So we said, okay. So what we ended up doing is we would settle orders by consent by describing the changes that we want. So, for example, in accordance with the attached plan, version L, 2 new lots created to the south of the existing lot. No part of the dwelling house constructed on the 2 southern lots shall be constructed to the north of the northern extremity of the defendant's house, along a dashed line. No buildings. This covenant concern a view in Mount Martha. Okay, so it did require a degree of precision. And it might not make sense the first time you read it, but it was sufficient for us to convince the court that it would be effective in controlling views from one house behind the front circle across the plaintiff's building in front. Okay, so there you have an extract from the title. So this is all about preventing the impact on views of this property. Then you can have plans of subdivision that have 3-dimensional building envelopes. Now, the extent of notice. Remember before when I said the Planning and Environment Act process talked about you have to notify all beneficiaries? That's not the case in the Supreme Court. The judge will exercise a discretion as to who to notify, and will generally only require the closest beneficiaries to be directly notified, but potentially with a sign on the land to notify anybody else. But there is a practice in the Supreme Court. If there's not a large number of beneficiaries, then we will quite often invite the court to only notify by direct mail those people who've got the benefit of the covenant. Because the last thing you want to do is notify people without the benefit of the covenant by putting a sign on the land. And then you find that you get a non-beneficiary financially supporting somebody who does have the benefit by proxy, and then you end up, effectively running a de facto planning dispute in circumstances where if you only notify the beneficiaries, you don't have that problem. But of course, that circles back to the importance of making sure that you identify with precision who's got the benefit of the covenant. So that's the extent of notice, and an example here of a court saying, yes, we want you to notify all those people who are identified in the land purple. The court rarely exercises power to discharge a covenant entirely. Now, we often get invited by developers to remove covenants, and we have to explain, well, yes, I understand that's what you want, but the court will very rarely give you a blank check. The court wants to know what you want to do and will allow you to modify the covenant such that it enables you to achieve that vision. Well, they're not going to remove the covenant unless you can show that it is somehow ineffective. It may be a personal covenant, and the person for whom the benefit is deceased, or it might be nonsensical because it identifies land that never had the benefit of the covenant, or something like that. Those are circumstances in which you can get a covenant removed. But typically, the court wants to know what you're going to do. It'll modify the covenant to allow you to do that and nothing more. So I'll typically have to convince you as a potential plaintiff that yes, I understand that you want to remove the covenant, but let's just take it one step by step. Maybe you don't need to modify. Maybe you don't need to remove the covenant entirely. You simply need to modify it. Section 84(2), the court has the power to declare what the effect of a covenant is. Construing a restrictive covenant. That's really of issue, I think, or of interest to solicitors more than people wanting to modify covenants themselves. Building materials covenants we've talked about. Principal and tonks costs. Okay, we'll close, I think, on the question of costs. What you need to know is that if you are seeking to modify a restrictive covenant in the Supreme Court, the court will see you as a party bound by a property obligation. That is, there are other people who have property rights in the benefit for your covenant. And they will say you're asking the court for an indulgence to effectively remove yourself from that obligation or to modify that obligation. And so it makes sense that you should indemnify people against or who come forward to pose your application. Now, that is modified in a number of cases, or there are exceptions to that. And that's why you need to be very careful when you're running these cases. You need to set yourself up well with offers of compromise. You need to make sure that the steps that you take in the litigation process are not frivolous or wasted or in any way an abusive process, because then the court will sting you as the objecting beneficiary, notwithstanding the fact that you're a beneficiary. So you've got to be really careful. And there are some exceptions to this. But again, the point that I want to communicate to you is that if you run this to a contested case, you need to be very careful about the costs exposure from the party posing your application. Now, conversely, you may be watching this this video thinking, or listen to this audio by thinking, well, in actual fact, I want to object to somebody modifying a restrictive covenant, which this will be of converse interest, inverse interest to you. I will say this: you need to essentially divide the litigation process into two parts. There is the first part, which is the application to the court, the notice to beneficiaries, and then the return of that notice back to the court. That's really the first stage. And we find that anything up to 90% of cases are resolved as pretty much as part of this first and second step, or as part of this first stage. What I'm describing as the second stage is when you have put out your application, you've got notice back, you've negotiated with the beneficiaries, and you still can't get an outcome, and you end up setting it down for trial. Okay, and that's when your beneficiaries, your objectors, turn up to court. They're legally represented. They're about to incur the expense of a town planner or some other evidence in order to run the case against you. And that's where you've got to be really careful, because at that stage, you're potentially on the hook for the costs being incurred by your opponents. So again, from that point on, you need to be really careful about how you're proceeding. But the reason I'm dividing this into two sections is that the first section, you can pretty much anticipate what your own costs are going to be. You're going to need a solicitor, you're going to need a barrister, in most cases, you're going to need some form of expert evidence. Not always, but mostly. And you're going to need some evidence from yourself as the permit applicant or the plaintiff. You can go through this first stage pretty much knowing what your expenses are going to be. And we often say, listen, you don't know who's going to object. You might get the whole community coming out against you saying, you know, we'll fight you all the way and, you know, over my dead body. But in truth, that rarely happens. And most of the time, what happens is that you'll get a few letters of people saying, well, you know, I'm not really happy about that. Or they might say, I want to know more about that, or expressing some kind of concern, but you can deal with those people. Okay. And as I say, most disputes resolve at this stage or shortly thereafter. It's only when you've been through that process and you come to me and I say, I'm afraid this really is going to run to a contested hearing, and your opponents are going to spend anything upwards of $25,000, $30,000, then you need to be very careful about commencing that second process or proceeding with the application. But again, we often encourage people to go through the first part of the process to basically assess what the opposition is like, because you really don't know until you try the process. Now, the importance of costs in restrictive covenant applications. So there's a fair bit of detail about that here. But really, I think that brings us up to enforcing a restrictive covenant, which is if you find that someone's building in breach of a restrictive covenant, there's a few salutary lessons there for people who really want to do the wrong thing. Manderson and Wright, someone built a dwelling in Barwon Heads in defiance of a restrictive covenant and had to pull it down, and then got stung for, I think, for $230,000 costs. Wasn't a good outcome. Combined permanent amendment application process, that's really for infrastructure projects or projects of some social significance, because you've got to get council support. Example of that is the lovely modern museum in Kew that went through that process. Would have been unsuccessful had it gone through the Supreme Court, is my guess, but it was successful because they went through the modification for the planning scheme amendment process. But again, you have to have some pretty good political support to succeed in that place. Removing a covenant by mistake. There's some discussion about restrictions on title under the Subdivision Act there. Again, I think of interest to solicitors more than lay people. And then some description about, or some analysis or commentary on process that we've had about the reform process in Victoria. So that really concludes the things that I wanted to say, or an overview of these notes. I hope it's been helpful. You're more than welcome to contact me, ideally by email, if you've got any questions. or by mobile phone if you're really desperate. But otherwise, I'm more than happy to answer any questions and help you if I can. I hope it's been useful.